So let's talk about the places where we basically agree on stuff. And I guess when I look at this stuff, I am not a sort of hardcore rational choice person, but I do tend to start from the presupposition that rational choice is a very useful way to understand these problems, to understand how institutions, including legal institutions, arise. I also believe, I'm an international relations scholar, I believe that state interests have to figure very powerfully into whatever explanations you want to come up with. But I do think that one could make the argument, and this is to start with the theoretical side of your approach, I think that one could make the argument that rational choice is by no means necessarily as hostile to the kinds of, so to at least some of the aims of global legalism as I think the book suggests. You know, so if I give, here's one example which is on page, page 29 of your book. You state, some international law emerges spontaneously as custom, but when states seek to solve global collective action problems, they can only do so by creating treaties. A state can only be bound by a treaty if it consents to it. Thus, a treaty that will solve a global collective action problem requires the consent of all states, or of all states that contribute to that problem. I think this is, to me at least, is a considerable overstatement of what rational choice theorists would actually say about this stuff. And here I'm talking, for example, Russell Harden has this Account in Collective Action, one of the original books on the field that I think you indeed cite, that more or less argues you don't have to have everybody agreeing in order to solve a collective action problem. Where all you need sufficient actors agreeing and being prepared to contribute resources to sort of cover the shortfalls from other actors who aren't prepared to cooperate in a particular situation. So, in other words, you don't need unanimity, which I think is really the burden of the argument that you're trying to put forward here. And this, I think, is reinforced when you look at the international arena by people like Todd Sandler, who have these really very sophisticated analyses of all of these very different collective action problems that you may face in the international realm. Some of them indeed require unanimous action on behalf of all states involved, but a lot of them do not. And so I think that the difficulties of solving collective international or collective action problems at the international level are maybe somewhat exaggerated in the particular version of rational choice that you're presenting here.
Well, I'm not sure we disagree about this. I mean, so let's take the case of the different, as Sandler and others have argued, there are different types of strategic problems that states face, and some types of problems are pure public goods, but only involve a few actors. So let's suppose that we have a number of states that border on a lake, and there's a fishery in the lake. And let's just say it's 3 or 4 states. And it wouldn't surprise me if they could enter into a treaty that would allow them to exploit the fishery efficiently rather than overfishing it. There's only a few states there. Or consider a global problem which really involves, let's say, coordination more than the sort of pure public good situation. And people have talked about this in your field for a long time, but communication and transportation standards are an example. Where, for example, there are various equally good ways of communicating, but the states have to agree on a single wavelength or group of wavelengths for their communications. And it's not a very difficult. It might be hard at the bargaining stage to agree, but once an agreement is in place, it's not very hard for the states to comply with the agreement, because it's in your own self-interest, if you want to communicate, to stick to whatever you agreed to. And then there are problems that are sort of in between that may or may not be solvable. And my claim isn't that any type of cooperation is impossible. But the focus of the book are the big problems, the big global problems, climate change, disease, the spread of disease, war, those sorts of things. And they do need they do require treaties that involve the participation of pretty much all states or a very large number of states. Those are the ones that I worry about. And there are kind of models in game theory where in fact everybody ends up cooperating because everybody promises to punish everybody who cheats and to punish those who fail to punish, and so those things are all theoretically possible, but in practice it's hard to believe that the empirical conditions exist for allowing that type of cooperation, because it requires an enormous amount of information that just doesn't exist in the world. That's why these institutions are built in the first place. So I'm not saying that international law is impossible, or even very ambitious types of international law are impossible on rational choice premises. I just think the types of international law that international law professors argue for I'm more skeptical about those types of international law. And partly, I would say I'm making a methodological point, which is just that if you want to propose something new, like a landmines treaty or an international criminal court, the burden should be on the academic or scholar or whoever who proposes it to explain how, in fact, this institution is, in the jargon of economists, incentive compatible. That is, why it would be in the interest of states to comply with it. That's really been missing in the literature.
Okay, but I guess to push back in a certain sense, so you could interpret your criticisms in one of two ways. One, that the global legalist approach to this stuff is fundamentally and effectively impossible because of problems that are revealed by rational choice theory. The second is that global legalists, as you say, tend to be somewhat allergic to rational choice theory, and that they might come up with better and more plausible accounts of the kinds of stuff that global legal rules can or cannot do if they paid more attention to incentive compatibility. That seems to be more what you're arguing right there. Is that a correct understanding? Yes.
And I don't want to. I'm not a doctrinaire rational choice person either. I think in the end, everything depends on empiricism. So again, I'm criticizing people who don't try very difficult, people who do not use rational choice, but and propose different theories, but don't try very hard to test them empirically. And so I'm willing to be persuaded by empirical testing, but I haven't seen it, at least not in the international law literature, and at least I have read in the political science literature. I'm just skeptical about some of the efforts in that literature. So that's the book is probably best understood as a plea for skepticism, and it's motivated more by history. A sense that if you look back throughout history, international law has been very weak, and the question is, what accounts for the sudden enthusiasm for it? Is this enthusiasm for it based on reason, evidence, a good sense of what mechanisms are available, or is it just a kind of enthusiasm which we've seen in the past at various periods, but has always not ended up being very productive?